I'm truly deeply sorry, and I know now that all I was trying to do was defend myself. It was simply self-defense. I'm a mother of 5 kids, and I'd like to go back to see my kids. I didn't see them for Christmas, Thanksgiving, or New Year's.
Thank you.
All right, I do. The police report says that you were chasing her with a knife,
No, ma'am.
and they say that there's a video of you chasing her with a knife.
No, ma'am, I did not chase her with a knife. I was simply scared running because there was 2 women after me. Not only 1, 2.
Okay.
All right, this is for sentencing, correct?
It is, Your Honor. Yes, it's PSI.
All right, who's the prosecutor on Annette Idrago?
PSI, you guys.
Is this criminal trial division?
Yes, Your Honor.
All right, Jason, are you on this?
Yes.
Okay. Everyone, we're going to go on the record. So, counsel, if you can ask the deputies, they'll move you down there. You're welcome. And do not, as a reminder, do not approach the bench or the coordinator or the clerk when we're on the record. Court is calling 2023 CR 7274, State of Texas versus Annette Idrago. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense.
Good morning, Your Honor. Daniel De La Garza for the defendant.
And are you Annette Idrago?
Yes, ma'am.
You entered a plea of guilty on November 16th. According to the plea bargain agreement, punishment is to be assessed at 9 years in the prison. There's an affirmative finding of deadly weapon, and the state is silent on your application for deferred adjudication. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor, we're reviewing it right now, but since you're silent, I'm fine with reviewing it and going on.
All right. Defense?
I have reviewed it, Your Honor, and showed the same to my client.
All right. Any objections to the PSI report? Defense?
No, Your Honor.
All right. All right. The state is silent. Defense, do you have any witnesses?
We don't have any witnesses, Your Honor. I would just like to point out that Ms. Idrago's husband is in the courtroom.
Okay.
Her father is also in the courtroom. He's standing. She has a supportive family, that kind of stuff.
Okay.
I don't think the testimony is necessary. I can argue it and it's in the PSI. But
Okay.
so we have no witnesses.
All right. Well, if you want to address with your client, because there's where it says guilt acknowledged, there's an X there, which I'm assuming guilt is acknowledged, but there is also an X that says guilt is minimized.
And I could ask you some questions, Judge. And
Sure. Can you raise your right hand for me, please?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record, please.
Annette Garcia Hidrogo.
All right, make sure you keep your voice up so that the court reporter can hear, all right?
Okay.
All right, defense.
thank you, Your Honor. And you know you're here for sentencing today, right?
Yes.
And you pleaded guilty to aggravated assault with a deadly weapon,
Yes, sir.
right? Now, tell the judge at the time, and it's in the PSI, we talked about it, but tell the judge at the time that this was happening, what was going through your mind?
Self-defense, Your Honor. I was
And-
simply trying to defend myself. I'm sorry.
Okay, that's fine. And then now, since I've become your lawyer, you've looked at the evidence and all that kind of stuff.
Yes.
Have you realized now, do you know whether it was self-defense or not?
Yes,
And you think that it was not, or do you think it was
I
self-defense?
believe in my heart it was self-defense.
Now, do you take responsibility for what happened, though?
I do know now that it's, in my mind, in my heart, it's self-defense.
But you know now that it
But I
was,
know, yes, sir.
tell the judge that it was
I
what?
do know now.
All right, so I'm sorry, if
Yeah,
you all
I mean,
can
yeah.
slow down and one at a time.
So tell the judge whether you think now this was self-defense or whether this was illegal.
I know now it is illegal, but at the time it was self-defense.
All right, so then the question is, do you take responsibility and do you acknowledge the guilt for the aggravated assault with a
Yes,
deadly
sir,
weapon
I do.
case? Hold on, aggravated assault with a deadly weapon case. Do you acknowledge your guilt?
Yes, sir.
And what are you asking the judge to do today?
If I would please get probation. This is my first offense. I simply was scared for my life, trying to defend myself.
And tell the court, why should the judge put you on probation?
Like I said, I know now if this would never happen again.
First off, right?
Right.
Do you have a criminal history?
No, sir, I don't.
Maybe a very limited one from Hidalgo County,
Um.
like a harassment or something that's on the.
none of
All
that.
right, everyone, one at a time. Okay, go for it.
Okay, and if you're granted probation, do you know that there's terms and conditions that come along with it?
Yes, sir, I do.
Are you going to follow all those terms and
I'm
conditions?
willing to comply all the way.
Are you gonna use drugs while you're on probation?
No, sir, I don't use drugs.
You don't have a history of drug
No,
use, right?
sir.
Are you going to work?
Yes, sir.
And the
Working.
PSI says that you're a caregiver, right?
Yes, sir.
Are you able to go back to some kind of job like that?
Yes.
Now, what if the judge says you're not able to work as a home care provider or anything like that? Are you able to find other kind of employment?
Yes, whatever is suitable for me.
Where would you go live?
My parents at the time being.
And do they live in close proximity to Miss Hernandez, Miss Tracy Hernandez?
No,
If the court orders you to stay away from the complainant in the case, would you stay away from her or would you go back to the Goodwill and?
no, I have no business. in your house.
Is there anything else that you'd like to tell the court before we stop?
Just that I'm truly deeply sorry, and I know now that all I was trying to do was defend myself. It was simply self-defense. I'm a mother of 5 kids and I'd like to go back to see my kids. I didn't see them for Christmas, Thanksgiving, or New Year's.
Thank you, Your Honor.
All right, any questions? All right, I do. The police report says that you were chasing her with a knife,
No, ma'am.
and they say that there's a video of you chasing her with a knife.
No, ma'am, I did not chase her with a knife. I was simply scared running because there was 2 women after me. Not only 1, 2.
All right, am I,
Well, Judge, I don't know really what to make of this because lots of times we can say, well, the person has a mental illness, health, issues, they're on drugs. I don't know really what to make of this other than it's a one-time kind of incident thing.
where's the video?
It's in the discovery.
Any objection to the court seeing the video? Just, if you all have it, if I could see the video?
Thanks. A bit of time.
Sure. Because she's saying self-defense, and I'm being told that the video,
And I
there's a
think-
video that shows something differently.
Yes, Your Honor, but I think now she realizes it's definitely not self-defense. This is
Okay.
not a self-defense.
All right. So what I want to know is whether or not she was chasing somebody with a knife or not.
Probably I was scared, ma'am.
No, you said you were running from 2 women,
Yes, there were 2 women after me, ma'am.
but
And
the police report says that you were chasing the complainant with a knife. So were you chasing the complainant with a knife or no?
yes, to defend myself and run from, there was 2 women to defend.
If somebody's running away from you and you're chasing them with a knife, how are you defending yourself?
No, there were 2 women and one of them were after me.
Okay. All right. Well, we'll see the video, see what the video shows. All right. And Dinah, I'll make sure that the video is emailed to you for your record. So if you all don't mind just stepping back a little bit while they pull up the video.
Sure. Just a real brief argument, Your Honor.
Okay.
What we're asking you to grant Ms. Idrogo's application for deferred adjudication. You saw the video, Your Honor. In her mind, it was self-defense. I certainly understand the chase and all that kind of stuff. And she now understands how it is not self-defense. Nonetheless, Judge, she definitely takes responsibility for her actions. She's asking to be supervised by the court. I think she would benefit from some anger management and classes that help her deal with these kinds of situations and how to get herself out of these kinds of situations. So the long story short is, Your Honor, based upon her limited criminal history, her lack of drug use, the fact that she takes responsibility, we ask that you grant the application. Thank you.
Anything else you wish to say? Ms. Drago?
I just ask that God may touch your heart and understand that like All I was asking is that if the Lord could hear me right now, he'd understand how much I repent of what happened that day. But it simply is just a self-defense in my mind, even though I know it's wrong.
Okay.
Thank you, Your Honor.
All right. Thank you so much. All right, so this is what the court is going to do. The court has heard all the evidence, and I want you to know that I internalize everything and I look at cases on an individual basis. The court is going to deny your application. Court will find you guilty. Court will sentence you to 3 years in the prison, give you credit for any time served. Take in consideration NIMAC number 714-465, NIMAC number 723-973. There's an affirmative finding of a deadly weapon. Is there anything else with regards to sentencing?
No, Your Honor.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Counsel.
Welcome.
Thank you.
Thank you very much.
Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Maybe excuse, Your Honor.
Yes.
Thank you.
Do you need anything?
Yes. Yeah. Tell them, we'll be breaking at noon. Okay, sure. All right, thank you. I will. Matthew Castro. Did you speak with his attorney, Norma? Matthew Castro? Yes. Come forward. Of no contest on December 5th. According to the plea bargain agreement, the state is silent on your application. They're taking in consideration 2022 CR 3280. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections to the PSI report, state?
No, Your Honor.
Defense?
No, Your Honor.
Defense, any witnesses?
Yes, Your Honor. I call Andre Carruthers to stand.
All right. Carruthers? Deputy Laura, we have a witness. All right, Mr. Carruthers, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth so help you God? All right, you can lower your hand, state your name for the record.
Andre Carruthers.
All right, defense?
Yes, Your Honor. How do you spell your last name?
Corrothers.
And are you what is the type of your relationship to Latasha Jenkins?
My boyfriend.
Right? And are you the complainant in this case?
Yes, sir.
And, and this is the incident that occurred May 5th, 2023, is that correct?
Yes, sir.
Okay, and you understand the accusation and the offense that Miss
Oh, just 1 second
Jenkins.
off the record for a moment. Excuse me. If y'all could move down to this end. All right, you may continue, counsel.
Thank you. And you know the charge that Miss Jenkins is facing?
Yes, sir.
Okay, and it's an aggravated assault with a deadly weapon.
Yes, sir.
And she has applied for the deferred adjudication, which means a type of probation that there will be no conviction if she follows the guidelines and does not commit any other offenses or comes up positive with drugs.
Yes, sir.
You understand that?
Yes, sir.
And are you opposed to Ms. Jenkins getting probation?
Am I against it?
Are you against it?
No, sir.
Okay, so you are in support of that?
Yes, sir.
And there is also a provision perhaps that the court may impose that there will be no contact with you if she's granted probation. Are you aware of that?
Yes, I was told.
And do you oppose the contact order?
Yeah.
And do you oppose no injurious or hazardous contact? Are you in favor of that? Which means
Yes.
the two of you or she cannot have or give you any kind of injury or
Yes,
be a hazard to your health.
Yes, sir.
You think that that would be okay with you?
Yes, sir.
Okay. And concerning the incident, what type of injury did you receive?
It was like a scratch.
Scratch?
It was like a scratch.
So there was nothing else besides that? Okay. And were you two on drugs at the time?
Yes, sir.
What type of drugs were you doing?
Yeah.
And she cannot be having, if you two are in contact with each other, she cannot be having or be using drugs. Would you be able to support that, given that you're also a drug user?
Yes.
Are you still using
Against
drugs?
it. No, sir.
I'm sorry, I can't hear you.
Are you still using drugs? Yes or no?
No, ma'am. Oh, no, ma'am.
Passed away. Did you?
All right, any questions?
No question, Chairman.
All right, so I see here that she stabbed your bag several times. No. According to the police report, it says that she started cutting up your bag.
Did I know?
Okay. All right, thank you.
I call Latasha Jenkins to stand.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Sure.
All right, you can lower your hand, state your name for the record.
Natasha Jenkins.
All right, defense.
Ms. Jenkins, you applied for a type of probation known as deferred adjudication probation, is that correct?
Yes.
And that is a type of probation that if you do not comply with the requirements of that community supervision, deferred adjudication, the judge has the full range, if you violate a condition, the full range of punishment, anywhere from as low as 2 or up to 20 years. Are you aware of that?
Yes.
Okay, do you intend to abide by the conditions of probation that the court may impose?
Yes, sir.
And why do you think that is the case?
Because I'm changing my life. I sat in Dare County for almost a year and I completed successfully classes, got certificates. I got recommendations from the teachers and unlock programs for the outside community to better be successful with our mental health and my substance abuse and me, period.
And the programs that you completed, are those included in, Defense Exhibit 1? Is that correct? Do you recognize Exhibit 1?
Yes, sir.
And Exhibit 1 consists of 8 pages of certificates covering, the different programs that you attended,
Yes, sir.
and that includes anger management, is that correct?
Yes, sir.
And also, therapy groups
Yes, sir.
and Microsoft Word
Yes, sir.
and Excel
Yes, sir.
and exhibit number 2, what is that?
The letter to the judge Boyd from Lisa Rodriguez, the unlock program.
Okay, and what type of program is the online program?
They help you with any classes that you need that the court orders for you. They help you with the fees. It's for continuing care. It's a reentry program. They help you with anything that you need to help me get back on my SSI, get my SSI started again. And to get me with a part-time job, whatever SSI allows me to work outside of SSI.
In few words, is that they help you to reintegrate yourself to society?
Yes.
Okay. I offered exhibit 1 and exhibit 2 for,
Any objection?
No, Your Honor. State has reviewed these.
All right, then Defense Exhibit 1. And Defense Exhibit number 2 is admitted into evidence.
now, prior to this incident, were you on SSI?
Yes.
And were you also working part-time?
Yes.
And what do you intend to do, or what are your plans if the judge were to grant you a deferred invitation?
Get back on my SSI and continue a part-time job that SSI allowed you to work and maintain my mental health.
What type of mental health illness do you suffer from?
Bipolar and PTSD.
And were you on medication at the time of this incident?
No,
Okay, and are you on medication now?
yes.
Okay. And do you have a place to stay
Yes.
if you were granted probation?
Yes.
And where would that be?
My brother's house.
And does he know that that's what you're planning to live?
Yes, he's been supportive for me since I've been in the back.
Do you have any children?
No.
That's the way to do it.
Any questions?
No, Your Honor.
All right, why did you cut your boyfriend with a knife?
We were into an altercation and I didn't intentionally do it. When I pulled it out, it was like a scratch that was gone like within maybe minutes.
All right, why were you cutting up his bag?
I don't remember cutting his bag up. I don't remember that at all, cutting the bag.
All right. Why have you not been successful on previous probations? Because I see that you've been on probation in
Yes,
Des Moines, Iowa.
Yes. I was in Des Moines, Iowa. My mother died. My husband went to federal prison. My brother left state. I was the only one there. I had no support system there. And I was going house to house. I couldn't maintain employment.
What is the escape?
Oh, it wasn't escape. It was dropped from escape. I left from the place that they sent me to after I got out of jail. It was a involuntary absence. That's what they dropped it.
No, and where did they place you after you were released from custody?
It was like a halfway house
Okay, and you left without permission.
on Sunday.
And then, so that's from 2007. And then 2011, you were placed on probation again and revoked. And all of this is out of Des Moines, Iowa.
Yes,
Then in Knoxville, Illinois, you were revoked from probation there as well.
Knoxville, Iowa.
No, it says Knoxville, Illinois, Marion County.
Yeah, that's Iowa.
Okay. And
Yeah.
then Hamilton County, Illinois.
Iowa. I don't know why they put Illinois.
Okay.
Exactly.
All right. And then Dallas County.
Yeah, that's Iowa too. Iowa was just a bad area. Since I left there, I have been so much better. Like, I was like, my life was not great there at all. I had no support there. Like I said, like my mother died, my brother left town, my husband went to federal prison. My life was just not great there. That's why I left there and came up here and lived
All right.
and
Well,
started my life.
I've read defense, I've read all your exhibits and I've read your letter
Yes, ma'am.
from Ms. Rodriguez. I appreciate you presenting these to me because it gives me a chance to know the person that's before me. And I also am taking in consideration the testimony of Mr. Carruthers. However, I don't think you'll be a good candidate for probation. So I'm going to find you guilty. There's to be no contact with Andre Carruthers, Tiffany Sansom, Sansom. There's affirmative finding of family violence, taken in consideration 2022 CR 3280. I'll sentence you to 3 years in the prison, give you credit for any time served. I've actually given you less than what was requested. And there's also an affirmative finding of a deadly weapon. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? All right, because this is a plea bargain agreement, because I've actually given you less than what you bargained for. And because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence and also an affirmative finding of deadly weapon and a conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Ms. Jenkins, good luck to you, okay?
And, is it possible if I get my 2-for-1?
You'll have to, here's what people don't understand. 2 for 1, 3 for 1. The court is not in charge with that.
Oh.
It's whatever institution you're at, they're in charge of what credit they give you. What I can tell you, you will at least be receiving time for every day that you've been in jail. And whether they want to give you good time credit or not, that's dependent on the institution. But if there's an issue, for example, let's say hypothetically, you've been in jail for 50 days. If you feel like you're not getting credit for those entire 50 days, then your attorney can come back. But if you want 100 days or 150 days, that's something with the institution. It's not something that I can give you. All right, good luck to you. Diana. Who's this? And I'm going to see about them giving you this. Okay. And Diana, if you give this to Daniel and they'll pull the, yeah. All right, we have interpreter and then John Lyles. Who's here for John Lyles? All right. So we have the interpreter on Armando Regalado.
Yes, sir. We're waiting paperwork. I checked.
Oh, yes. Regalado, just have a seat.
Judge,
Yes.
we're gonna have paperwork in a plea today, we anticipate. We will need an interpreter,
Okay.
but probably if a victim in flex statement, we're gonna have sentencing formally ask them that be tomorrow.
Sure. Okay, thank you. And then Arturo Campos Toledo.
Morning, Your Honor.
Good morning. Where's your client?
He is present right here, Your Honor.
Hi, good morning. Happy New Year.
Happy New Year to you.
We made it.
Yes.
All right, so on this case, the last time we were here, CPS records had been turned over. The school records of the complainant, I think, were outstanding, and some sort of medical record was to be uploaded. So has the medical record been uploaded?
I believe all of this has been uploaded, Your Honor. You said the CPS records had already been turned over?
Yes, that's what I have from last time, that the state had the CPS records and they have been turned over.
So don't believe the defense counsel received those. I have drafted a protective order so we can get that done. Judge.
All right, thank you.
And just for the record, Your Honor, I did review the forensic interview and the CPS records yesterday, but with the agreed order, we will be getting them diet content.
Okay, sure. Okay, and then the school records of the complainant?
I believe we did receive those. Sorry, Judge. It's been a minute since I've looked at that. I believe we did receive them, Judge, and I made sure that everything was uploaded, but I will double check that for.
All right, and then the next thing is some sort of medical records?
I believe that was for the sane examination.
Yes.
Your Honor, and I do have those records.
Yes, Your Honor, that has been uploaded. And the defense has also made their own application for the school records as of early yesterday. It shouldn't be an issue having that provided.
All right, and I understand he has an ice hole, but Teresa Coles Davila was appointed for immigration purposes for the impact this case will have on his immigration status.
That is correct.
So where's the status of that?
I have had an opportunity to speak with her, provide her with a copy of the indictment and some background information.
I'm sorry.
That's okay. If you repeat that.
Yes.
I have spoken with Ms. Davila, Your Honor, provided a copy of the indictment and some background information, but we're still pending a PDA letter.
Okay. Did she give you an idea of how long?
No, Your Honor, but I don't anticipate much longer because she's very diligent about it.
Oh, yes. All right, so state, when will you be prepared to make an offer?
We've extended a new offer, Your Honor, to defense counsel. We started talking yesterday. I extended a new offer today. Additionally, I just wanted to let the court know that I've already let defense counsel know. I did drop off 3 videos for translation. I do not speak Spanish, so I do need to have those translated. I dropped them off for an unofficial translation on December 15th and an official translation on December 18th, Your Honor. The official translations do take much longer to be done, but I've not received a notification for the unofficial translations that they're ready yet. For the court's information, one of the videos is rather lengthy at about 5 hours, so it may take them a little bit of time.
All right, this is what the court will say. And if it's unreasonable, let me know that it's unreasonable. So I'm going to reset this for 60 days. And that will be your plea deadline date. And at that time, you'll have hopefully the unofficial transcript. And of course, if we're going to trial and you want the official transcript, just let the court know and let me know what the time constraint is on that.
Yes, sir.
So your plea deadline date will be in 60 days. What date is that?
March 7th.
All right, so we'll be back on March 7th. On March 7th, you'll need to let the court know whether or not you're accepting the state's offer. If you choose not to accept the state's offer, your plea deadline date will have expired. The court will not consider any plea bargain agreements without good cause. Otherwise, you have to plea open to the court. Do you understand?
Okay.
Is that a yes or no?
Yes.
All right. Is there anything else from either side? All right. Thank you.
Thank you, Your Honor.
Yes. Yes. Happy New Year. It's so good to see you. Oh, yes, I did. Always with mom is great. Yeah. Oh, that is so awesome.
Of course.
Of course.
Thank you.
John Lyles, who's the attorney for John Lyles? Norma, is the attorney able to come back in the afternoon?
Oh, he just went to. He'll be right back.
Okay, well,
Sorry about
just,
that. I'm like, who's talking?
all right, just give me that one. You're ready.
I can look at the phone.
Michael Martinez, and after Michael Martinez, it will be Aran Bwani, Tomas Hernandez, and Philip Diller. So who's here for Michael Martinez? All right, where's Michael Martinez?
Your Honor, I have spoken to him. He has transportation issues and is not able to make it this morning.
All right. Well, he already has a bond forfeiture, so there's already a warrant out for him
Okay.
since December 12th because he did not appear on that date either.
Okay,
So,
okay,
all right, thanks.
okay.
No
Thanks, Judge.
problem.
May I be excused?
Yes, I'll put a notation on here that you showed.
That I'm here.
Yes.
Okay. Thank you, Judge.
You're welcome. Aran Bawani? Yes. And counsel, you're on this side now.
sorry.
That's okay. That's it's a New Year's change. All right. Happy New Year. All right. So last time we were here, there's an issue with school records out of Ohio.
Yes, I don't, I do have some records. I don't know if it's a comprehensive list, but I did speak with Anna today. I had not spoken with her previously.
Okay.
Um,
So what, do we know what discovery is outstanding?
I'm not sure about those school records. Sorry, Judge.
No problem. I don't know if you were here last time.
I was not here last
Right.
time.
So last time there are some school records in Ohio.
I'm not seeing anything new in the file, Judge. I'll look into that.
All right. Any other discovery, counsel?
Judge, I think that's it. I think that's all.
All right. So, and you say you've received some records from Ohio?
Some records from Ohio, I think it was like in the nature of a police report.
All right. So if you'll let the state know, maybe they can help get the record sooner. All right, Ms. Ferguson, on this case, if you're reset for 45 days, and that will be the last discovery date.
Gotcha.
And are there child protective services records in this case or no?
I don't have any CPS records, I believe, Judge, just a forensic interview.
Okay. All right, 45-day reset.
February 22nd.
All right, we're going to come back on February 22nd. And at that time, state if you'll be prepared to make an offer.
Yes, Judge. I believe an offer's already been conveyed on this case, Your Honor, but we'll continue our conversations.
Yes,
Okay.
Your Honor.
Maybe it'll change after the Ohio records. I don't know. All right, thanks for dressing appropriately for court.
Thank you.
All right, once you sign the reset form, you're excused.
Thank you so much.
Thank you.
Let's have a seat.
Oh, no wonder I'm looking at the wrong docket. Tomas Hernandez. Hello, Happy New Year. You don't have the cane or walking aid anymore.
I do not.
Congratulations.
Thank you.
You're becoming the bionic man.
There you go.
All right, so today an offer is due.
I have received that offer, Judge. We would like opportunity to have my client come over to my office between now and the deadline.
All right.
Okay.
All right, Ms. Ferguson, can you recall this at the end of January for plea deadline date, please? All right, January 30th, that will be your plea deadline date. At that time, you'll need to let the court know whether or not you're accepting the offer. If you choose not to accept the offer, the court will not consider any plea bargain agreements without good cause. Otherwise, you have to plea open to the court. Do you understand? All right, thank you.
Thank you.
Just once you sign the reset form, you're excused.
Just wait for the son and I'll get to the son. Get back to them. Appreciate it. It's been worked out. Yeah, thanks. Good. Let's look, this will take care of the next couple of weeks. That should be good.
Philip Diller. Hello.
Morning, Judge. Happy New Year.
Oh, Happy New Year. All right, Ms. Ferguson, we need a jury trial date on this. The earliest jury trial date. How long do y'all expect this trial to last?
At least a week.
Are there videos?
There aren't, Judge. The state would maybe have a day and a half maximum worth of testimony.
All right, Norma, this is going to be probably 3 days.
Can do April 9th.
That's the earliest you have?
And I can try to.
I mean, because this case has been pending for a while, since 2022.
You can come back on the 16th then.
January 16th?
Yeah.
All right, that's your jury trial date, January 16th. All right, thank you. Just sign the reset form. Thank you for dressing appropriately for court.
Thanks, Judge.
Denny, are you ready on your case or no? All right, could I see the file on, what is your client's name?
I'm working on it.
Oh, okay, thank you. Oh, she's working on it now. And Deputy Lori, do you know if Karen Munoz has made it?
It actually en routes.
Okay, awesome. Thank you. Jose Gutierrez.
Judge.
Good morning. Hello. So do you have all the discovery?
Judge, I'm not sure if I got all of it, but we're just looking for a plea deadline date. I got an offer, and I'll confirm during that time whether I need any, or I have it all. So
All right, State, have you uploaded all discovery?
As far as I'm aware, Judge.
All right, Ms. Ferguson, on this case, it's Jose Gutierrez. Can you give me a 2-week reset for a plea deadline date?
25th. January 25th.
All right, January 25th is your plea deadline date. At that time, you need to let this court know whether or not you're accepting the state's offer. If you choose not to accept the state's offer, then your plea deadline date will have expired and the court will not consider any plea bargain agreements without good cause. Otherwise, you'll have to plea open to the court. Do you understand?
Yeah.
All right, thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
thank you, Judge.
Thank you. Janelle Williams. Who's the attorney for Jonelle Williams? And counsel, you're on this side. Are you rich? Oh, I'm just reading the, yes. Hey, think it and it will happen. You have to put it in the universe first. You ready? Okay. And I know it's the style. I don't know why it's the style that people think that wearing pajamas in public is the thing to do, but that's not allowed in this courtroom. You understand? So if you come back in this court again wearing pajamas, we're going to have issues. And I always say, it's like the commercial we used to watch when I was growing up, G.I. Joe. And at the end of G.I. Joe, they would always have a segment for children about what you should know. And they would end with the more you know. So the more you know, now you know that's not appropriate dress for court. And usually what's not appropriate dress for court is coming in with writing on shirts and everything. Because sometimes they say things that you don't want them to say. For example, if you were in child support court, you don't want a jersey that say rich, right? Yes. Because people would say, well, your child's not rich because they're not getting child support. I would always have to tell my clients all the time in child support court, why are you showing up in here with diamonds in your ears and gold chains? And they're telling that your child doesn't have their child support. Why do you have on Gucci and all this name brand stuff? Right? So no pajamas, no slides, no flip flops. You understand? This is court. You're supposed to present yourself the way you want the public to see you, right? All right. So where are we on discovery?
Judge, I think that we should have everything. I received an offer from the state today.
Okay.
I plan on, we'll go over all the discovery with Mr. Williams and make sure that it's all there. And then we should be hopefully on the next court date prepared to.
All right, Ms. Ferguson, on Mr. Williams, set this in 3 weeks for a plea deadline date. How old are you? 19? All right, so I'm going to give you longer since you're only 19. Are you in school?
No.
Did you graduate?
Yes, ma'am.
What are you doing with your life?
Work right now
Doing what?
at Amazon.
All right. So you're planning to move up in Amazon, perhaps become a manager or whatever?
Yes, ma'am.
They have commercials about Amazon where you can actually earn a degree. Are you working on that?
Not yet. I do plan on getting into a trading school.
So what do you do at Amazon?
But just usual warehouse stuff, just moving boxes and loading trucks.
Okay. All right. Make sure my packages get on the truck
Yes.
and tell them don't just be throwing. Although I know they put them on a tight schedule, which I think is ridiculous. That's why you see people racing and throwing packages. They showed some video of, somebody sent me a video of a girl who was upset because she had to do Tetris in her truck to get everything fitted in. And she said, for the love of all that's holy, will people start ordering dogs, bagfuls of dog food because they're so heavy? She's like, just go to the store. This is heavy for me to lift. All right, Norma, 3 weeks plea deadline date.
What do I have to do, February 6th?
All right, February 6th is going to be your plea deadline date. Are you working on February 6th?
I'm not sure. Is it what Thursday through Sunday?
All right, let's see what February 6th is. February 6th is a Tuesday. All right. So don't be the person who's 90 years old and you're still doing the same thing at Amazon. And I say this because you're very young. Try to move up. All right.
Yes.
Because at some point in time, guess what? They're going to get rid of the people who are just loading boxes and they're going to let machines do it. If you go to Walmart, if you go to HEB, you have self-checkout. I never go to self-checkout because you know what I know? They're getting rid of the cashiers. That's what that self-checkout is. Nobody believed me when I was a young child. You know what else? They used to have self-serve at the gas stations where people would pump your gas, check your wiper fluids, clean your windshield and do all of that. They don't have that anymore. Now you have to pump your own gas and they charge you more. All right, good luck. Once you sign the reset form, you're excused, okay?
Judge.
You're welcome. Bye-bye. Who's here on, okay, I've already done that one. Yeah, that's done. Adriana Harrison? All right, court is calling 2023 CR 9045W and 2022 CR 10906W, State of Texas versus Adriana Harrison. Can I have parties announced for the record for the state?
Anna Ochoa Nelson for the state.
Danny Callahan, defense.
Are you Miss Harrison?
Yes, ma'am.
All right, we were here previously and the court informed both parties that I would not be accepting the plea bargain agreement. It's the court's understanding that you all have reached a new agreement. Is that correct?
Yes, Your Honor.
All right. We're going to proceed first in cause number 2023 CR 9045W. Counsel, have you received all the discovery in that case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Harrison, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Harrison, I'm going to show you what's entitled Court Admonishments. Well, let me backtrack. Ms. Harrison, this case was not indicted, although I know the rights and waivers have been tendered to you. I'm going to go over those again. Do you understand you have a right to have the grand jury hear any evidence in this case and make a decision on whether or not to indict?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you understand your attorney has certain rights, namely 2 days from the presentation from the information and 10 days from the presentation of the information to prepare for trial?
Yes, ma'am.
Did you understand that by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
And did you review the information with your attorney and did you understand it?
Yes, ma'am.
And counsel, do you waive the reading of the information?
Yes, Your Honor.
State, are you proceeding on the information as presented?
Your Honor.
Going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Okay. Did you understand you're charged with the offense of aggravated? I'm sorry, you all don't talk behind the court reporter. Right here, excuse me.
Mr. Meadows. Mr. Meadows.
Thank you. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Ms. Harrison, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, you're to be sentenced to 5 years in the prison. There's an affirmative finding of deadly weapon. There are no applications. The state will take in consideration 2023 CR 10983. Is it everyone's intention that this case, if I follow the agreement, is to run concurrent with the probation case?
Yes, yes,
Right.
Your Honor.
And then it will be concurrent with cause number 2022 CR 109006W. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Oh, Your Honor.
And also, is this a family violence case?
It is a family violence.
All right, did you understand if the court, from reading the stipulations or any evidence that's presented, if I determine that this is a family violence case, then I will enter an affirmative finding of family violence. Did you understand that?
Yes, ma'am.
And did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
And did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
All right. All right, then to the offense as charged, how do you plead? Guilty, not guilty, or no
No
contest?
contest.
State any evidence?
State offer states exhibit 1 with attachments.
Any objections?
No
Oh,
objection.
sorry, Judge. No objections.
No, you're offering states exhibits 1 and attachments?
Yes, Judge. It's been a long day.
No problem. Any objections?
Objection,
All
Your Honor.
right. Ms. Harrison, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Pursuant to our agreement, Your Honor, Ms. Harrison has a right to ask you to bend the plea agreement and give her, or rather reinstate her probation. And that support thereof in the PSI, it shows that they say she didn't have a mental health or didn't take mental health treatment because she attempted suicide, but she did. I want to make that correction. In her hand are 2 completions of self-rehabilitative efforts in the jail of family violence. But she has a right to ask that outside of the agreement of
Yes.
5 years. I asked the court to follow the agreement, but perhaps to consider taking both cases and putting her back on probation. Lastly, her mother's here in court and supports her. That's a good sign. Because of her past, she still has not thrown in the towel for her daughter. Do you want to talk to the judge?
Yes, sir.
All right, you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Adriana Harrison.
All right, defense.
May she make a narrative statement, Your Honor?
State, do you have any objections to the narrative?
No objection.
All right.
I just want to say I apologize for my action. I just want to say I apologize for my action on my behalf with my daughter. I owe her a deep apology for acting the way I acted. And let's just say sorry to you for ending backing up in front of you, Judge. And for you to please give me another chance.
All right, what's your daughter's name?
Ariana.
Okay.
That all? Nothing further, Your Honor?
All right, anything from the state?
No, Judge.
All right. You want to explain that to me?
I was trying to get my daughter back.
No, why do you have a knife in your hand?
Explaining this.
And how old is your daughter?
She just turned 2.
All right, so do you realize that your daughter remembers you with a knife in your hand?
Yes, ma'am.
You need to work on your anger issues because this isn't the first time that you've been to this court for anger issues. And I know your mom says, well, would probably say, oh, she needs help with her mental health or she needs help with her drug issues. That's what I was giving you when you were on probation for that, and you didn't take advantage of it. You just doing whatever you want to do. So I don't know where your anger issues stem from, but you need to get those under control because otherwise, you know what's going to end up happening? You're going to end up being a habitual. You know what that means in Texas?
Yes, ma'am.
That means if you pick up another felony, depending on the type of felony, your minimum is 25 years in prison.
Yes, ma'am.
And then if you go to prison for 25 years, when you come out, your child will be an adult. Hopefully your child will not be before a judge with a defense attorney saying, oh, my mom pulled out a knife when I was 2 years old and I was there to witness it and she was being violent to her girlfriend and she went to prison. So I didn't have anybody to raise me. That's what's called the cycle. And that's what ends up happening when you do these things.
Yes, ma'am.
All right, the court will follow your agreement, sentence you to 5 years in the prison. There's an affirmative finding of deadly weapon. There's going to be an affirmative finding of family violence. Take in consideration 2023 CR 10983. This will run concurrent with 2022 CR 1090W. There's to be no contact with Diamond, DYAMOND Jones, Dylan Angeles, DYLANANGELES, and there's to be no unsupervised contact with minors. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Could you pass that, please? Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because it's a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we're going to move on to 2022 CR 10906W. I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Adriana Kisna Harrison, who was placed on deferred adjudication in 2022 CR 10906W for the offense of continuous violence against family on November 5th, 2022 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 1, on or about the 6th day of September 2023 in Bear County, Texas, the defendant Adriana Kisna Harrison committed the offense of aggravated assault with a deadly weapon in violation of condition number 1.
How do you plead to that? True or not true?
The state waives and abandons all remaining alleged violations.
Any objections?
No objection.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Your Honor, we would ask that you revoke probation at this time, that the defendant be sentenced to 5 years in TDC, and that it run concurrent with her other aggravated assault with a deadly weapon, which you just sentenced.
All right, is that the agreement?
Yes, Your Honor, ask. Pursuant to the agreement, she's permitted to ask you to ignore it and put her back on probation, nothing further.
All right. Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, then the court will follow your agreement. The court will grant the motion, find you guilty, revoke, sentence you to 5 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with I think it's Taquidra, Taquuiedra Evans. There should be no unsupervised contact with minors. And I'm sorry, what was the cause number for the other case? Does anybody know offhand? Yes.
2023 CR 9045W.
And it's to run concurrent with 2023 CR 9045W. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence and a conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, ma'am.
All right, we can go off the record. You're going to have to do better. And obviously, you should not be in any relationship with anyone until you get your life together. And you should not be in a child's life until you get your life together, because children learn by what they see and what they hear. When you see a child who's using profanity and they're young, they didn't just like all of a sudden start using profanity. The people around them use profanity. And when you have a child who sees violence in their life, they start thinking that's the way you solve problems, by using violence. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
You're welcome. Christian Gomez. Court is calling 2023 CR 0218, State of Texas versus Christian Eduardo Gomez. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense,
A federal plea for the defendant, Christian Eduardo Gomez, Your Honor.
are you Christian Eduardo Gomez? You're going to need to speak up.
Yes, ma'am.
Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Christian Eduardo Gomez who was placed on deferred adjudication in 2023 CR 0218 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on March 28th, 2023 for a term of 3 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor. Violated condition number 20, on or about the first day of July 2023 in Bear County, Texas, the defendant Christian Eduardo Gomez did then and there contact Kayla Benavides in person in violation of condition number 20.
How do you plead to that? True or not true?
True.
We'll waive the remaining violated conditions, Your Honor.
Any objections to the waivers?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 20, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 20?
Yes, ma'am.
Court will find violation of condition number 22. Is there a proposed agreement?
There is, Your Honor. It is to deny the motion to adjudicate, continue him on as deferred, and to have alter and amend his conditions to include SATIP with aftercare, and then upon release, he sends to ISP caseload. And also reiterate that he is to have no contact with Kayla Benavides.
All right, is that the agreement?
Yes, it is, Your Honor.
Probation?
That is the agreement, Your Honor.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth or nothing but the truth, so help you God?
Yes, ma'am.
I'm sorry, the truth and nothing but the truth, so help you God.
Yes, ma'am.
All right, you can lower your hand. Why are you not doing well on probation?
I admit I did have a drug problem during the probation, and I didn't take advantage of that. But I was aware that I had to turn myself in, and I knew I was going to do that when I stopped reporting, ma'am. But unfortunately, I got put over with a friend before I was able to do that.
Oh, you know what? People are always intending to do things before life steps in.
Yes, ma'am.
So you're pulled over with a friend. So you're telling the court that you and your friend At least your friend was driving you to the jail to turn yourself in, but you all got pulled over.
No, ma'am, that's not what I was saying. At that day, I was just heading home. My intention was to turn myself in after the new year. I wanted to spend the New Year's with my family, but it didn't go that way.
How old are you?
22 years old.
All right. I want you to hear me and hear me clearly. You are looking at going to prison for 10 years. Would you like to go to prison for 10 years? Then you had better start doing what's asked of you on probation. Otherwise, you're going to be in prison for 10 years. You know that orange outfit you're wearing? Does it have your name tag in it?
No, ma'am.
Yeah, somebody else had that on. I don't know if they're washed in uniforms at the jail or not. I know they're not using Downy. I know they're just using detergent that says detergent on the box. And if you have an allergic reaction to that, that's on you. Somebody just sent me a video of roaches fighting. I don't know who won, but I mean, the bunch of roaches fighting. They send me video of no ceiling towel. Is that the way you want to live your life?
Of course not.
I have students that I teach in college. I always take them to a tour of the jail because I tell them, if you want to be a defense attorney or prosecutor, you need to know where you're sending people. So we always go to the jail. They're astounded. I know that when you're at the jail and you need bathroom tissue to use, you have to ask for it. If they tell you 2 squares, like from Seinfeld, where Elaine was like, all I need is a square. That's all they give you, a square. And it's the same thing for the ladies. 2 squares, here you go. Me, I prefer the mint method where you just, that doesn't happen at the jail. So here's the thing. I'm going to deny the motion and you are to have no contact with Kayla Benavides. Who is she to you?
Next girlfriend.
All right. That relationship is over. How long have you known her?
5 years.
All right. So you've been alive on the planet longer than you've known her. So you cut her loose because she doesn't want you anymore. If you're around her, if you contact her, if you send her a birthday card or flowers or anything like that, a motion to revoke is going to be filed and you're looking at 10 years in prison. You understand?
Yes, ma'am.
Coach, if I may,
Yes.
just to also reiterate, she was actually contacting him at times, so if you might want to admonish him on that also.
Here's the thing. If she calls, you don't answer. If she comes by your house, call the police. Say, I'm not supposed to have any contact with her. You understand?
Yes, ma'am.
Move on. Obviously, you all are not good together. That's why they want the non-contact order. I'll do a referral to felony drug court. That'll be first, followed by SATF with aftercare. So if felony drug court doesn't accept him, then he'll be going to SATF.
Yes, Your Honor, we will need a tap.
All right. And then we'll do a TAP evaluation. Is there anything else you need from the court to be successful?
No, ma'am.
All right. And just so you know, I had already put no contact with Kayla. So I've written it down twice. So if you come back before me with contact before Kayla, we're going to have some issues. You understand?
Yes, ma'am.
All right. You better do better. I know you don't want to go to prison, but that can happen. All right. Good luck to you.
Thank you.
Thank you.
Thank you.
Issa Johnson. And everyone, we're recessing at 12. And Norma, is it me or is it hot in here? No, it's not. Deputy Laura, is it hot in here?
It's hot.
Thank you. Norma, you're gonna make me think I'm having a hot flash and I'm not. You know, I'm in the twilight of my life. I'm gonna send an email. Court is calling 2023 CR 9442, State of Texas versus Issa. Is it pronounced Issa?
Isaiah.
Isa?
Isaiah. Isaiah.
Isaiah Johnson. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
David Andre Woodard for Mr. Johnson.
All right. Counsel, have you received all the discovery? Did you review it with your client?
I have, Judge.
The court will find that the state is in compliance with discovery. Mr. Johnson, I'm showing you what's entitled application for deferred adjudication. Did you review that with your attorney? Did you understand it? And did you sign it? showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented? Mr. Johnson, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes.
Did you understand you have that if you entered into a plea bargaining agreement, court doesn't need to follow your plea? If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Judge.
Mr. Johnson, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, punishment is to be assessed at a cap of 8 years in the prison. The state is silent on your application. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Counsel, any such motions?
No, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Contest.
State, any evidence?
Yes, Your Honor. I offer State's Exhibit 1 and the attachments.
Any objections?
No objections, Judge.
State, you may continue to confer. Showing you what's entitled Waivering Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulation. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Will we be needing a MIC evaluation?
Judge, I don't believe so.
All right. All right, then your hearing will be set for February 8th. I'm going to schedule PSI and TAP. At that time, I will make a decision on your application based upon any evidence that's presented to me. Do you understand? All right. Thank you.
Appreciate it.
Judge, did you say February 8th?
Yes.
Okay.
Okay, we have the interpreter though. So I'll take that one next. Sure, if he's coming back, but tell him I'm taking the interpreter first. If the interpreter will come forward, Mr. Behrens, your case, I'll take it after I finish with the case involving the interpreter. All right, if you all will come forward, please. And it's Armando Regalado. Court is calling 2023 CR 7943, State of Texas versus Armando Regalado. Can I have parties announced for the record for the state?
Ahora Ochoa Nelson.
Humberto Saldaña for Armando Regalado.
Excuse me. Y'all need to move to the other end if you want to talk in the box while we're on the record. All right. And are you Armando Regalado?
Sí.
Yes. All right. We have an interpreter here. If you could raise your right hand. Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand. Mr. Saldana, do you speak Spanish?
I do, Your Honor.
And do you speak it fluently?
I do.
And were you able to communicate with your client in Spanish?
I was.
And were you able to go over the entirety of the documents with your client in Spanish?
Yes, Your Honor.
Sí.
Yes. Okay. And did your attorney go over this with you in Spanish?
Sí.
Yes. All right. Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Yes. Mr. Regalado, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Sí.
Yes. Counsel, do you waive the reading of the indictment?
We do so well.
Did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places? Yes. Did you understand you're charged with murder? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Sí.
Yes. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Sí.
Yes. Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Sí.
Yes. Did you understand by entering this plea, you were giving up those rights?
Sí.
Yes. And did you intend to give up those rights and enter into a plea in this case?
Sí.
Yes. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes to both, Your Honor.
Mr. Regalado, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
No. Anyone promised you anything other than the plea?
No.
No. Are you satisfied with the way you've been represented?
Sí.
Yes. Are you a U.S. citizen?
No.
No. Counsel, did you advise your client of the consequences of entering a plea in this case and its impact on his immigration status?
I did, Your Honor.
Did that advice include possible consequences such as deportation, exclusion into the United States, or denial of naturalization?
Yes, Your Honor.
And do you believe he understands the immigration consequences of entering into a plea bargain agreement in this case?
I do, and we specifically spoke about that.
Mr. Regalado,
Sí.
did your attorney explain to you the consequences of entering into a plea in this case and its impact on your immigration status?
Sí.
Yes. Did you understand that potentially you could be excluded from entry into the United States?
Yes.
and the denial of naturalization,
Yes.
and the denial of citizenship.
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. According to the plea bargaining agreement, punishment is to be assessed at 30 years in the prison. There's a $1,500 fine. No applications. You're not eligible for an application on murder. There's an affirmative finding of family violence. There's to be no contact with Francisco Nahara. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Judge, I believe it's the family of.
The family of Francisco Nahara. Did you understand that to be the plea?
Yes.
Thank you. And did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counselor, are there been any such motions?
No.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offers Exhibit 1.
No.
Did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. Court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Off the record for a moment. Counsel, I realize that you have someone who's going to want to do impact.
That's correct, Judge. She's available tomorrow.
All right, so I can sentence him today and I can have him come back over tomorrow.
Yes.
Is everyone okay with that?
That's all right, Judge.
All right, so we'll recall him for tomorrow, Ms. Ferguson. All right, any objections to proceeding with sentencing?
No objection, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we would just hope that you would follow the agreement that we have with the state.
All right. Court will sentence you to 30 years in the prison, give you credit for any time served. There's an affirmative finding of family violence, affirmative finding of deadly weapon. There's to be no contact with the family of Francisco Nahara. There's a $1,500 fine, time and money to run concurrently. And there's to be no entry into the U.S. unless legal.
Yes.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, thank you. All right, we'll go off the record. State, if there's no objection from the defense, if your witness would like to appear by Zoom instead of in person at the court, I know parking is at a premium. They're more than welcome to do that if the defense has no objection.
Judge, but they should prefer to be here to do it.
Okay, all right. And Norma, if you'll make sure there's a hold on him and we'll bring him over tomorrow. All right, thank you so much. Good seeing you.
My pleasure. May I be excused, Your Honor?
Yes. All right, Juan Carlos Olade. Court is calling 2023 CR 11027C, State of Texas versus Juan Carlos Olade. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Robert Barnes for Mr. Olaude on behalf of Ms. Green.
All right. Are you Mr. Olade? Do you have any objections to Mr. Barron standing in for Ms. Green? You need to speak up.
No.
All right, and I'm gonna need you to speak loud so the court reporter can hear. Can I have the staff, please? That's okay. Counsel, have you received all the discovery and did you review it with your client?
Yes, Judge.
Your Honor, this was the co-defendant from the case yesterday.
Two cases yesterday.
Yes,
Right. So
thank you.
can I put that on the record?
Yes.
Your Honor, I spoke with defense counsel in the presence of the other defense counsel for the co-defendants in this case. There were several issues that came up that I could have looked into and I said I would look into. I still made an offer and all the defendants decided to take that offer.
Is that correct, counsel?
That is true, Judge.
All right, the court will find that the state is in compliance with discovery. All right, and this is an application for deferred adjudication, is that correct?
Yes, Judge. Yes.
All right, for some reason, the court does not have that. Mr. Olade, are you applying for deferred adjudication?
So that?
Are you applying for a deferred adjudication? All right. Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment? State, are you proceeding on the indictment as presented?
We are, Your Honor.
All right. Mr. Olade, you're charged with the offense of burglary of a building with intent to commit theft, showing you what's entitled court admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand that that offense is a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
We've talked about some defense, Judge. He's been able to assist in his defense, but he's elected to take this plea.
All right. Do you believe he has a rational as well as a factual understanding of the charges against him?
I do. I believe he's competent to enter his plea.
All right. Do you believe he was sane at the time of the offense?
I do.
Mr. Olade, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $400 fine. State recommends deferred adjudication. There's to be restitution to Andrew Fott. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Judge.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there been any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation, 100 hours community service restitution, and CATS 1 and 2. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence?
State offer states Exhibit 1 and all contents.
No objection.
All right, you may continue to confer. Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand that? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Judge, we have an application.
Oh, I'm sorry. You're right. After reviewing states, it's been a long day, a long new year, and it's barely started. All right. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt because you applied for deferred adjudication. Are you ready to proceed with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Mr. Aldo's only contact with the justice system before this was a DWI back in 2014. As opposed to the other defendant who I believe had some forms, a little more of a record. I understand the court had extended their probation term to 3 years as opposed to the recommended 2 years. I'd ask the court to consider sticking with the 2-year recommendation for Mr. Olvaldo.
All right. Mr. Olati, are you planning on continuing your relationship with Lydia Maria Valdez?
Lydia?
Yes.
No.
Oh, she was here. Well, I mean, you were here in the box when she was here and she claimed you as her boyfriend. That was Sanchez?
Yeah.
Okay. All right. So you have no contact with her? With Lydia?
No, I don't know who's that.
All right. And you have no contact with Victor?
Victor, no.
Okay. All right. Are you employed?
Yes,
What do you do?
I do lawn service.
All right. Do you have any children?
No.
All right. Where are you going to be? Well, who will you be living with if you're released today?
With my boss.
All right. This is what the court will do. The court will sentence you to 3 years deferred adjudication, regular reporting by Zoom or in person, restitution to Andrew Fraud. Counsel, if you feel as though the restitution is inappropriate, we can have a hearing on it.
All right.
$500 fine to be probated, cats 1 and 2. There's to be no contact with the following: Lydia Maria Valdez, Victor Javier Escobar. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider with minors. TAP evaluation out of custody. You to follow the recommendations of TAP, accept probation. If they recommend inpatient treatment, we'll start with outpatient treatment to see how that goes. There's to be no unsupervised contact with minors. 100 hours of community service restitution. Field visits 1 time per month until TAP completion. And regular UAs. Probation, is there anything else he needs? Is there anything else you need from the court to be successful? All right.
Judge,
If you,
if I
yes,
may,
yes.
You said a $500 fine probated. I think the agreed fine was $400.
No, I said 400 probated.
Okay.
Yeah. Thank you. All right. Anything else you need from the court?
No, Your Honor.
If you complete everything successfully, your counsel can always come back and ask for early termination. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, good luck to you. We can go off the record. Don't take what doesn't belong to you, okay? All right,
Thank you, Judge.
thank you. Paul Perez. I need a PSI date for this, please. Okay. Oh, he is? Okay, well, somebody stamped it as though he was not set today. Okay. Oh, no problem. All right, court is calling 2023 CR 8695, State of Texas versus Paul Anthony Perez. Could I have parties announced for the record for the state? Defense?
Your Honor, good morning. Frankie Sandoval on behalf of Mr. Pettis.
And are you Mr. Perez?
Yes, Your Honor.
All right, you entered a plea of no contest on October 24th, 2023 to the offense of aggravated assault with a deadly weapon. According to the plea bargaining agreement, punishment is to be assessed at a cap of 6 years in the prison. There's an affirmative finding of deadly weapon, and the state is silent on your application, and there's to be restitution. Have both parties had a chance to review the PSI report, state?
No, I haven't. I was unaware that Mr. Sandoval was here. present.
Okay, no problem. I think we only requested the TAP evaluation and criminal
Yes,
history.
That'd be fine.
Yes, Judge.
And so, do y'all have criminal history to tender to me? All right. If y'all need time to get that, I can call the next case. All right, no problem.
Your Honor, if I may, on behalf of Mr. Pettis and for efficiency purposes, Your Honor, although PSI was not done, the TAP evaluation was done. And there was a notation on there about him being slightly motivated for treatment. And in my discussions with Paul over the last 6 months, shortly after him just turning 18, being arrested for this, he's well aware that his future is at a crossroads, that his entire life is at a crossroads, and that the activity with respect to substance abuse and his experimenting with that needs to change. That was not in and of itself the reason for what gave rise to this incident. Through no fault of his own, financial hardships led his family to living in a, for lack of a better term, a group home, which was a highly stressful situation. Mr. Pettis has reflected upon all this. As I said, he had just turned 18 upon his arrest. He's been in custody for 6 months, will not turn 19 for another 6 months.
So counsel, let's just wait until the state is ready to give me the criminal history.
Well, okay, well, I would just inform the court with respect to the slightly motivated portion of the TAP evaluation. Oftentimes it comes across as the lack of motivation, where what's really intended is he doesn't want to be a problem to anyone.
All right.
Judge, your motion.
Thank you. Any objections to the court reviewing the?
No, Your Honor. In fact, we appreciate it and
Just judicial dialogue, Your Honor.
All right, thank you.
That's as an adult and then yes, in previous juvenile.
All right, counsel, you may continue.
And Your Honor, Mr. Pettis presents himself, and I say Mr., it really should be, as I said, yeah, it should be Master Pettis, presents himself seeking a chance from this court as an adult under the criminal justice system. He has not had an opportunity to prove himself, not to the court or to the state or to myself, but to himself and what he can accomplish, especially given the sword of Damocles which hangs over his head should he fall short, if this court in its ultimate wisdom were to allow him community supervision and the opportunity to turn his life around. I was taken by the court's attention paid to another young man earlier today. As odd as this will sound, Your Honor, it may sound odd to everyone in this courtroom, but what I wouldn't give as a 58-year-old male to be in Mr. Pettis's position right now, even though he's in an orange jumpsuit and in handcuffs, he's 18 years old and he has his whole future ahead of him. And what I wouldn't give to be 18 again. And if he only knew now what I know and what we the judges far away from my advanced years, but what we now know. And it's given the totality of the circumstances of this young man's life, society would not be harmed, given the localized tension that gave rise to this event, and him being given an opportunity. And if that opportunity also includes, we've discussed, Mr. Pettis and I, the necessity of some sort of substance abuse treatment, even inpatient, to begin the process, to allow him to, again, not prove himself to this court or myself or Judge Garahan or anyone else, but to himself that this is not him. And it does not have to be him, nor does it need to define him. And Mr. Pettis presents himself to this court. Should the court have any inquiry, or should Judge Garahan have any inquiry of him?
All right. State, you're silent on the application, but according to the plea, it's a cap of 6 years.
It's a cap of 6 years silent.
Oh, and you're silent on the cap as well?
Yeah, yes.
Okay. All right. Has anyone had any contact with the complainant?
We had some previous contact, Your Honor. They're aware of the,
Anything you wish to say, Mr. Pettis?
I just want to say that I know what I did was wrong, and I'm very sorry.
So can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Paul Pettis.
All right, so what were you two arguing about?
We weren't arguing about nothing. I literally just got out the shower and he attacked me.
That's not what it says in the stipulations.
That's what it should say.
That's not what it says. Do you want a jury trial?
No, I don't.
All right, so according to the stipulations, it doesn't say you were outside and he attacked you. So you say you just got out the shower and that's when he attacked you. I need you to say yes or no.
Yes, Your Honor.
All right. So you just get out of the shower, and I'm assuming you're nude because I don't know anybody who showers with their clothes on normally. So you were showering with no clothes on. Am I to assume that?
Yes, ma'am.
All right. So immediately upon getting out of the shower, did you have a chance to grab a towel or anything of that nature?
Yes, ma'am.
All right. So you grab a towel. Did you have a chance to wipe off with the towel, or did you just have it wrapped around your body?
I had a chance to dry myself.
So you dried yourself. Did you have a chance to put on clothing?
Yes, Your Honor.
So you put on your clothes. So when you say he immediately attacked you after you got out the shower, did this happen in the bathroom or where the shower is, or no?
No, I got out the restroom.
All right. So you're in the restroom, and immediately when you walk out the restroom door, that's when you're saying he attacks you?
Yes, he said, what's up, local? And I said, what's up? And then I turned around and he already had his shirt off and attacked me.
So had you stepped out of the bathroom when he attacked you?
Yes, I did.
All right. So I'm assuming that your bathroom does not have knives. Did you have a knife in your pants?
I did not.
All right. So where does the knife come in? Because he got stabbed.
I'm not sure.
Well, I mean, it says you had a knife. So from the time you're saying he attacked you in the bathroom, you dry out, you come out, there are no knives in the bathroom. So where did you get the knife?
I don't think it was a knife. I think it was scissors.
Judge watches the video, then rejects the defendant's self-defense claim. The defendant walked into court hoping for probation. Instead, one piece of evidence changed everything. She had already pleaded guilty to aggravated assault with a deadly weapon, but she asked the judge to place her on probation instead of sending her to prison. She insisted that in her mind, she had only been trying to defend herself. Her attorney argued that this was her first serious offense. She had no history of drug abuse. She was willing to follow every condition of probation. And most importantly, she accepted responsibility for what had happened. But the judge wasn't convinced. As she reviewed the case file, one detail stood out. According to the police report, the defendant had chased the victim with a knife. When the judge asked her directly if that was true, she initially continued describing the incident as self-defense. Then, after several follow-up questions, she admitted she had chased the complainant while holding the knife because she believed she was protecting herself. That answer immediately raised more questions. The judge requested to watch the surveillance video before making a final decision. Everyone in the courtroom waited. The video was played. The judge carefully watched every second.